Hello everyone and welcome to today's edition of the Daf Yomi. Bava Kamma Daf 71 Omad B. The Gemara asks, following on from last Omad, granted, according to the one who said that the products of a prohibited act are prohibited by Torah law, it's for this reason that the rabbis exempt the thief from the fourfold of fivefold payment when he slaughters an animal on Shabbat, as slaughter on Shabbat does not render the meat permitted for consumption. But according to the one who says that the product of a prohibited act on Shabbat may be eaten by Torah law but it's forbidden by rabbinic law, why do the rabbis exempt the thief when he appoints an agent to slaughter the animal for him and the agent performs the act on Shabbat? The Gemara answers, when the rabbis exempt him from the fourfold or fivefold payment, they are not referring to a case where the thief agent slaughters the animal on Shabbat. Rather, they were speaking of the rest of the cases listed in the Braita, namely an agent who slaughters an animal for idol worship and one who slaughters an ox that is sentenced to be stoned. The Gemara asks another question with regard to the interpretation of the Braita presented above, and with regard to Rabbi Meir, granted he maintains that the legal status of an act of slaughter not fit for accomplishing its full ritual purpose is nevertheless considered an act of slaughter. But why is the thief liable to pay a fourfold or fivefold payment when his agent slaughtered the animals for idol worship? Once he slaughtered the animal a bit, at the very start of the act of slaughter, he has prohibited the animal with regard to deriving benefit as an animal sacrifice to idolatry. When he slaughters the other part, it is already prohibited with regard to deriving benefit, which means that it is not an animal that belongs to the owner that he slaughters, and it is not an animal that belongs to him that he slaughters. Since deriving benefit from the animal is prohibited, it has no value, and therefore there is no ownership. Rava said this is referring to one who says prior to the slaughter that only with the completion of the slaughter does he worship idolatry. Therefore, the prohibition does not take effect until that stage, which is also when the liability to pay the fourfold or fivefold payment is incurred. The Gemara raises a question with regard to another of the case of the Braita. An ox that is sentenced to be stoned is an item from which deriving benefit is prohibited. Consequently, when the thief or agent slaughters this animal, it is not an animal that belongs to its owner that he slaughters, and it is not an animal that belongs to him that he slaughters. Why does the Rabbi Meir obligate him to pay the fourfold or fivefold payment? Rava said, with what we're dealing here. This is the case where the owner entrusted the ox to a bailey, and the ox fatally injured someone while in the bailey's house, and it was forewarned while in the bailey's house. Let's see the footnote. V'hoad bevei shomer. The issue of whether the ox is forewarned is not relevant here, as the same halacha applies to any ox that killed someone, and some versions of the text omit the mention of forewarning. It may have been added due to the similarity of this case to others. See, for example, 40a. And it was sentenced to be stoned while in the bailey's house. Benigma dina levei shomer. In this case, where the animal gored and killed someone while the bailey was safeguarding it, the court will normally put the ox to death, and the bailey will have to reimburse the ox's owner. Rabbi Yaakov maintains that if the bailey hastens to return the ox intact before its execution, he is exempt from any further payment. By stealing the ox from him, the thief has brought about a situation in which the bailey will have no other recourse than to pay for the ox in full. And the thief then stole it from the bailey's house and slaughtered it. Rabbi continues, and Rabbi Meir holds in according to the opinion of Rabbi Yaakov, and he also holds in according to the opinion of Rabbi Shimon. He holds in according to the opinion of Rabbi Yaakov, who says, even after the ox was sentenced, Av shen mishenigma dino. If an ox, while in the care of a bailey, killed a person and was sentenced to be killed, the bailey may not exempt him from payment by returning the now worthless ox to the owner. The halacha is not in accordance with the opinion of Rabbi Yaakov. Rambam Sefer Nazik and Hilchot Nikrei Mammon 11:9. To be stoned, and if the bailey returned it to its owners before it was killed, it is considered returned. Although the ox is now worthless, as no benefit may be derived from it, since the bailey returned a physically intact ox, the owner has no claim against him. And Rabbi Meir also holds in accordance to the opinion of Rabbi Shimon, who says, an item whose elimination causes financial loss is considered to have a monetary value. So what does that mean? Davar hagomin lemamon. An item whose elimination causes financial loss. Rabbi Shimon maintains that if one steals or destroys an item and thereby causes financial loss to another party, he must make financial restitution to the party who suffered the loss, even if the item is intrinsically worthless or does not belong to the injured party, or both. In the case discussed here, although the ox is considered worthless and the owner and ownerless after its sentencing, because the thief causes a monetary loss to the bailey, Rabbi Shimon would require the thief to pay restitution to him. The commentator asked, why did the Gemara invoke Rabbi Shimon here? By certain that Rabbi Meir, the Tana presently under discussion, would have to agree with the sage's ruling. The Gemara could have admitted any reference to Rabbi Shimon, as it is known that Rabbi Meir maintains that one is liable for indirect damage. For example, if one destroys a promissory note, Rabbi Meir holds him responsible for the note's full value, despite the fact that the destroyed paper is itself virtually worthless. That's what answered that in the case of a promissory note, the money in which it refers is worth something, as the debt can be transferred, sold, or traded to anyone. By contrast, an ox sentenced to death is of no worth to anyone except the bailey, who can use it to exempt himself from monetary payment to the owner's ox. Is considered to have a monetary value. With regard to an item that is otherwise worthless, if its elimination causes monetary loss due to the fact that it must be replaced, it is considered to be of value. In this case, although the ox is worthless in and of itself, when the thief slaughters it, he prevents the bailey from returning it intact to the owner and causes him to be obligated to pay the owner the value of the ox before it was sentenced to be stoned. Consequently, the thief must reimburse the bailey, as the ox effectively has value for that bailey. As we learn in the Mishnah 74b, Rabbi Shimon says, in the case of sacrificial animals for which the owner bears financial responsibility, Kadoshim shechayev ba'acha ra yuson. If one steals a sacrificial animal from its owner and slaughters or sells it, he is exempt from the fourfold and fivefold payment, even if the offering was of the type that the owner is obligated to replace. The halacha is not the same according to the opinion of Rabbi Shimon. Rabbi Seif and Nazir and Hilkaneva 2:1. There are differences between various categories of offerings. Some are usually obligatory, e.g. as the sin offering, while others are usually brought voluntarily. With regard to obligatory offerings, until the animal has been sacrificed, the obligation to bring the offering to the temple remains in force. If an animal designated to have an offering of this kind was lost before it was sacrificed, it would have to be replaced with another animal. With regard to a voluntary offering, responsibility to replace it depends on the wording of the individual's vow. If he merely said this particular animal shall be a burnt offering, he is not obligated to replace it if it becomes lost or it dies. If he said, I hereby accept upon myself that I will bring a burnt offering, and then designated a specific animal for that offering, and the animal was lost or died, he would have to replace it. If one steals an animal that has been designated to be a burnt offering and must be replaced if lost, then even though a sacrificial animal is no longer considered to belong to its previous owner, but to the temple treasury, since its theft causes him a financial loss, it is considered property for the purposes of this halacha. Consequently, the thief is obligated to pay him the double payment, or if he slaughtered or sold it, the fourfold or fivefold payment. To replace any of them with another animal, if it is lost or dies, the thief is obligated to pay the fourfold or fivefold payment if he slaughtered the animal. Although one is generally not liable to pay the double payment for stealing consecrated items, Rabbi Shimon maintained that this case is different, since as a result of the animal's theft, the owner sustains a loss by being required to substitute another animal for it. Since the animal's loss has financial ramifications for the owner, apart from any inherent value it has a value for him. Apparently, Rabbi Shimon holds that an item whose elimination caused the financial loss is considered to have monetary value. Rav Kahana said, I recited this halacha according to which the Mishnah follows the opinion of Rabbi Meir in front of Rav Zevid of Nahodea, and I asked him, is it correct to say that you can establish the Mishnah in accordance with the opinion of Rabbi Meir and not according to the opinion of Rabbi Shimon? And isn't it taught in the last clause of the Mishnah, Rabbi Shimon exempts the thief from the fourfold or fivefold payment in these last two cases? One can learn by inference that in all the rest of the cases in the Mishnah, apart from these two, Rabbi Shimon concedes that the thief pays the fourfold or fivefold payment. Rav Zevid said to him, no, that is not the correct inference from the Mishnah. Rather, by inference, one can learn that only Rabbi Shimon concedes that the thief pays fourfold or fivefold payment in the cases mentioned immediately prior to this one. Simply in a case where the thief slaughtered or sold the animal in order that it should be used for medicinal purposes or for feeding to dogs. Therefore, it can be correct to establish a Mishnah according to the opinion of Rabbi Meir and not according to the opinion of Rabbi Shimon. The Mishnah teaches if one stole an animal of his father's and then slaughtered or sold it, and afterward his father died, he pays the fourfold or fivefold payment to his father's other heirs. Rabbi raised a dilemma before Rav Nachman: if one stole an ox belonging to two partners and slaughtered and subsequently admitted the thief to one of the partners, Vahoda the echad mehem lechulu. So it could admit it to one upon. The commentaries ask, how is it possible for one to concede that he has stolen an animal without admitting that he's stolen it from both of its owners? Said the Rid. One suggestion is that the thief admitted to one partner in the presence of the court and he stole the animal, but later, when confronted by the second partner in a different court, he denied the theft, said the Bar. Alternatively, the Gemara is referring to a case where the thief claims that he is himself the second partner of the animal. In other words, he tells the first partner, I admit to stealing an animal, half of which you own, and I am the owner of the other half. In this manner, he admits owning to having stolen half the animal, says the Rid. Another possibility raised by the Rid is that when the Gemara says that the thief admitted the thief to one partner, this means that he not only admitted the thief to the partner, but he had already reimbursed him for the theft before he came to court. Which means that he's exempt from paying the fourfold of fivefold payment to that partner, in accordance with the principle that one who admits his own guilt is exempt from fines, or with regard to payment to the other partner. The Gemara explains the size of the dilemma. The most one stated in the Torah, he shall pay 5 oxen for an ox in Exodus 21:37, which indicates 5 full oxen, but not 5 half oxen. Or perhaps when the most one states 5 oxen, this means that even 5 half oxen must be paid in the case of this kind. Rav Nachman said to Rava, Mezman states 5 oxen, which means 5 full oxen, not 5 half oxen. Rava raises an objection to him from the Mishnah. If one stole an animal of his father and slaughtered or sold it, and afterward his father died, he pays the fourfold of fivefold payment. But here, since his father died and the thief has inherited part of the stolen animal himself, it is similar to the case of one who stole from 2 partners and went ahead and admitted the thief to one of them, i.e. to himself. In the case, the Mishnah is exempt from paying the portion of the fine that is for himself, and yet the Mishnah teaches that he pays the other heir their portion of the fourfold of fivefold payment. Rav Nachman said to Rava, with what are we dealing here? With a case where the father stood against his son, the thief, in his trial, and the son was convicted for the thief and slaughter of his father's animal. In this case, the liability to pay the fourfold of fivefold payment was established before the father's death, and at that time, the payment was 5 full oxen. Rava asked him, and if the thief had not yet stood trial before the father's death, what would be the halacha according to your opinion? Would not be required to pay the fourfold of fivefold payment? If so, rather than teaching the latter clause of the Mishnah in 74b, if one stole his father's animal and the father died, and afterward he slaughtered or sold it, he does not pay the fourfold of fivefold payment, and the Mishnah makes a distinction within the same type of case as follows. In what cases the statement, i.e. that the thief is required to pay the fourfold of fivefold payment, said, it is when the thief stood trial in his father's lifetime. But if he did not stand trial in his father's lifetime, he does not pay the fourfold of fivefold payment. Rav Nachman said to him, indeed, the Mishnah could have mentioned that case. However, since the Tana of the Mishnah had to cite the first clause, which discusses one who stole an animal of his father's and slaughtered or sold it, after his father died, he cites the latter clause as well by means of a similar case. If one stole his father's animal and his father died, and afterwards he slaughtered or sold the animal, this discussion between Rava and Rav Nachman occurred in the evening. On the following morning, Rav Nachman retracted his statement and said to Rava, the most one states 5 oxen, and this means even 5 half oxen are included. In a case where one steals an ox or a sheep that belongs to 2 partners and then slaughters or sells it, if he admitted the theft in one court to one of the partners, but denied the theft to the second partner, and witnesses subsequently testified that he stole the animal, he pays the value of 5 half oxen or 4 half sheep to the second partner, in accordance with the second ruling of Rav Nachman, Rambam Sefer Nezich, and Geneva 310, Tor Choshen Mishpat 350. Included, Rav Nachman explained he changed his mind, his change of mind. And the reason I did not say this to you last night is because I had not eaten ox meat. Dala achalei bisrod v'desora. Rashi explains this is a figure of speech that means I did not think about the matter to do it sufficiently. See the Yavitz. Others suggest that Rav Nachman mentioned ox meat in allusion to the verse 5 oxen for an ox, Exodus 21:37. Yet others read this statement literally. Rav Nachman excused his incorrect answer on the ground that he had not eaten anything that day, and had therefore become weak and not fully alert, says Tosfot. Eshel Avram explains that he meant that he had not partaken of nutritious food on the previous day, and therefore he was not as mentally alert as usual. See Tanya 1:7. That's the end of the Omid. Thank you for listening and all the best. Bye.